Boss, good morning. Fine, thank you, sir. Please, is this still with you or inside our own office? Okay. Okay, I've seen it. I've seen it.
Good morning.
Is this still with you or inside our own office? Okay. Okay, I've seen it.
Kayode.
Yeah, hello.
Hello, sir. Morning, sir.
Good morning.
Yeah, fine, sir.
Yeah.
Yeah.
So you're online, yeah.
Yeah, exactly. I'm online, but I can't hear anything at the background yet.
That means it's not started.
Oh, okay. I actually wanted to be sure because I was just seeing. I saw you, so I was trying to be sure that it has not started because I could hear them somebody talking somewhere.
Okay, if it's not, that means the job is coming in. We have not started. That's why you see the one that is LICN.
Okay. Yes, muted.
Yeah.
Okay.
So once you come, you will see them.
Oh, okay. Okay, sir. Okay, fine, sir. So please, I'm arranging that stuff. Please, I'm just definitely going to send it soon. Please.
All right.
Please, yeah. So the case is likely not trial yet, sir.
No, he's ruling.
Oh, okay, ruling. Okay.
For that preliminary objection.
Oh, okay. No, it's fine. It's okay. I think I even like this platform. It looks good because I was thinking of the traffic down and all that, but it's okay this way.
Yeah. I've moved to the office when I remember that I didn't pick my car with. I left it in the other car.
Oh.
So I have to rush back home.
Okay.
So that's why I have to do it at home. I was intending to do it in the office.
Good morning, Council. Hello.
Hello, good morning.
Okay, sorry. My lord will soon join now. Just trying to connect. Please, just be patient.
No problem.
So sorry for the delay and the
Why are you
inconvenience.
sorry? Our Lordship is the one helping us. There's nothing to be sorry for. We are the ones that should be deeply appreciative.
I was told to relay this information.
Thank you very much for that.
All right,
But we are online, we are waiting. If it was normal court day, we will sit down and keep our mouth shut and wait. So no issue. Thank you.
No problem, sir. Yes.
Hello. Council, can you? Hello. Hello, good morning.
Good morning, hello.
Good morning, Milord.
Yes. Can you hear me?
Yes, sir.
You can hear.
Yes, sir, we can
I'm
hear
very
you.
sorry. We're having a major challenge this morning. I'm not able to connect, so I'm using my phone now. I hope we'll be able to hear ourselves.
Yes, sir.
Yes, sir. Can hear you, sir.
Okay, we'll take the first case, which is Emmanuel Abia and IENG Nigeria Limited and another.
As the call, please.
Okay, those of you in this matter that are wrote, you may wish to remove your wig and gown. Please, are the parties present?
Yes, sir. The claimant is present, my lord.
Is Emmanuel Abia
Yes, sir.
present?
Present.
Okay.
Present.
Yes. What of the defendant? Any representative?
Yes. Present, my lord.
My Lord, the first defendant is present, represented by...
Hold on. Represented by?
Madam Grace, please give your names.
Okay, my name is Grace Efanebedia.
Mrs. Grace?
Egbedia.
Please spell the surname.
E-G-B-E.
E-G.
B-E.
Yes.
D-I-O-N.
D-I-O-N.
Yes, sir.
Okay, John. What's your position, please?
I'm the HR manager.
Appearances, please.
May you please, the Honorable Court.
Yes,
My name
please.
is Femi. My name is Femi, sir. Adisa Isikalu is a compound name, sir.
Yes.
Yes, sir. I announce my appearance for the claimant respondent.
May I please, my Lord?
Yes.
My name
Yes,
is
go ahead.
My name is Akintoye. Akintoye. Lord, I'm counsel on the record to the first defendant and the second defendant applicant.
Thank you. I sincerely apologize for keeping you waiting. I am awfully sorry. I've never had such challenges before. So please, I'm very sorry. I'll proceed to read the ruling and we'll take it off from there.
As the court, please.
As the court, please.
As the court, please.
This ruling would have been delivered on 26 April 2021, but for the strike by the Judiciary Staff Union of Nigeria. It is being delivered now due to uncertainty of our resumption. But thankfully, the strike was called off yesterday. So we are grateful that we can go back to court and do our work. Now, by notice of plenary objection. Hello, can you hear me?
Yes, sir.
Yes, sir. Yes, sir.
Please, I'm using my handset. so it may be a little difficult. So please listen attentively as much as you can. By notice of plenary objection dated 3rd July 2020 and filed on 6th July 2020, brought pursuant to Order 11 Rule 1, Order 7 Rule 6, 10, and 16, Order 8 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, hereinafter referred to as the rules, and under the inherent jurisdiction of this honorable court, the second defendant applicant prayed the court for the following orders. An order of the honorable court striking out the suit for being incompetent and for want of jurisdiction, and for such further or other orders as the honorable court may deem fit to make in the circumstances of this suit. Upon the following grounds, no service was effected on the second defendant. The originating process intended for the second defendant, who resides outside the jurisdiction of the honorable court in Beirut, Lebanon, was purportedly served at the office address of the first defendant in care of the second defendant. 3, the leave of this honorable court was not obtained, and the second defendant did not mandate the first defendant to receive service of processes for and on behalf of the second defendant. 4, the leave of this honorable court was not obtained, and the first defendant did not undertake to receive service of processes for and on behalf of the second defendant. 5, the purported service of the second defendant's processes on the first defendant is a nullity. The application is supported with 18 paragraphs affidavit deposed by Mr. Olukayode Ogunbamila, legal practitioner assisting Akintoye O. Ogun Akintokun Esquire, applicant solicitor. In compliance with the rules, the applicant filed a written address dated 3rd July 2020. In opposition to the application, the claimant respondent, hereinafter referred to as the respondent, filed 4 paragraphs counter affidavit dated 6th August 2020 and a written address of the same date. Arguing the application on 22nd March 2021, Mr. C.A. Jaja, learned counsel for the applicant, relied on the affidavit in support of the motion on notice and adopted the written address and submitted that the issue before the court is that there is no competent originating process before the court and urged the court to so hold. His response, Mr. A.E. Adeyemi, learned counsel for the respondent, relied on the counter affidavit and adopted his written address as his argument in opposition to the application and urged the court to assume jurisdiction over the matter in that the second defendant is the parent company of the first defendant. A summary of facts in support of this application is that the applicant is a company incorporated in Lebanon, and in issuing the originating process, the respondent used the address of the first defendant as the address for service on the applicant, and subsequently served the originating process meant for the applicant on the first defendant. It is the case of the applicant that leave of the court was not obtained to issue and serve the originating process on the applicant, which robs the court of the jurisdiction to entertain the suit. The respondent, for the respondent, the applicant is the parent company of the first defendant and carries on his business at the first defendant's address, where the originating process was received, and which address is within the jurisdiction of the court. Hence, leave is not required. The applicant submitted on issue 1. The applicant submitted one issue for determination in its written address in support of the application, to wit, whether there is a competent originating process in this suit. Relying on projects Jessica Enterprises Limited and Leventis Technical Company Limited as cited, learned counsel for the applicant submits that jurisdiction is the basis of the authority of the court to try a case, and the issue of jurisdiction can be raised at any time. He contends that the originating process is fundamentally and curably defective, and as a result, there is no originating process before the court on the authority of MBC PLC against Ajogun as cited. He also submits that by Order 7 Rule 16 of the rules, and Section 98 of the Sheriff and Civil Process Act, leave of court ought to be obtained before the issuance and service of the originating process involving a defendant who is resident outside the jurisdiction of the court, and non-compliance with these provisions is a fundamental vice, which goes to the root of the action. Reliance was placed on Egypt Nigeria Limited and Egypt Petroleum International as cited, and Caribbean Trading Facility Corporation and NNPC as cited. He further submits that leave was not obtained, rendering the originating process invalid and void on the authority of Biawuna, Obunyaya and others, and Obi Okudo and others. The court was urged to grant the application. The respondent formulated two issues for determination in his written address, that is to say, whether the second defendant having his subsidiary / branch office and place of business in Lagos, Nigeria, can be validly served with the originating processes in Lagos, Nigeria, within the jurisdiction of this court. 2, whether the originating process in this suit was properly served on the second defendant. On issue 1, learned counsel referred to section 54(1) of the Companies and Allied Matters Act 1990 and submits that the intent of the provision is to prohibit a foreign company from running a business in Nigeria without registration or obtaining an exemption certificate. He referred to paragraph 4 of the affidavit in support of the application and argued that there is nothing before the court to substantiate the claim that the applicant is registered in Lebanon, noting that the only way to prove registration is by production of a certificate of incorporation on the authority of NNPC and Luton Investments Limited and another, as cited. Therefore, in the absence of the certificate of incorporation, the court was ought to presume the applicant is registered in Nigeria. Arguing issue 2, it contends that a preliminary point ceases to be won if the point cannot be decided without leading evidence, in which case it becomes a defense to the action. The case of Elebanjo and Daudu was cited in support. Counsel referred to paragraphs 4, 6, 7, 8, and 9 of the affidavit in support and argues that the applicant alluded to one-sided facts without corroborating evidence and also relies on these facts in his defense, thus removing it from the realm of preliminary issue to be dealt with in limine. He submits that the object of service is to give notice to the defendant of the pendency of a suit against him. Kida and Ogumowala was cited. And since the applicant does business in Nigeria, it ought to be served the originating process in Nigeria in line with Order 7 Rule 1 of the rules and Section 78 of the Companies and Allied Matters Act 1990. Reliance was placed on NBC and Obani as cited. On the other hand, he argues that if the applicant is not registered in Nigeria, service on this branch office in Nigeria is not out of place on the authority of Order 7, Rule 1, Sub Rule 1 of the rules, noting that service of court processes by Section 78 of the Companies and Allied Matters Act is to be effected in accordance with the provisions of each High Court rules. Reliance was placed on Niswatch Communication Limited and ATA. Lastly, he submits that by entering appearance on the strength of an irregular service of a valid originating process, the applicant waived the irregularity on the authority of Ezomo and Oyekari. 1985 2 SC 260. The court was ought to dismiss the application for being baseless and frivolous with 200,000 naira cost against the applicant. The issue for determination raised by the applicant effectively addresses the question this court is called upon to answer, and I adopt it. That is, whether there is a competent originating process in this suit. Let me state here that the Companies and Allied Matters Act 1990 is no longer the extant law. It has been repealed and replaced with the Companies and Allied Matters Act 2020 and Section 78, subsection 1 of the Act, which is Section 54(1) of the old Act, has no relevance to this application. From the respondents showing, the applicant has complied with the law by registering the first defendant Thus, the issue no longer arises. In addition, it is not correct as argued in paragraph nothing before the court to substantiate the claim that the applicant is registered in Lebanon. The respondent averred in paragraph 3 of his statement of facts that, and I quote, as the defendant and the one that coordinates the business of the first defendant from his head up. This is an admission that the applicant is registered outside the Federal Republic of Nigeria. Facts admitted require no further proof. See Section 123 of the Evidence Act. There is therefore no burden on the applicant to prove that it is registered in Lebanon. See Section 136(1) of the Evidence Act 2011. As submitted by learned counsel for the applicant, jurisdiction is the lifeblood of any adjudication. Without it, the entire procedure and station Nigeria Limited, 2021, 1 Nigeria with 542 to 543. Elebanjo and another and Dawood are cited. It is now firmly established competent when three important conditions are Hello. Hello. Can you still hear me?
Yes,
Yes, yes, sir.
We had you up to
Okay, I lost you at some
Yes,
point.
my lord.
up to when three important conditions. We had up to that point.
Okay, that's where we stopped. Okay, these are one, it is properly constituted as regards number and qualification of the members of the bench, and 3.2, the subject matter of the case is within it prevents the court from exercising its jurisdiction, and the case comes before the court initiated by due process of law and upon fulfillment of any condition precedent to the exercise of jurisdiction. A defect in competence is fatal. Simadokulu and Ngendelem are cited. The originating process is the foundation of the suit on which the claims of the claimant rest. The validity of the originating process affects the competence of the claims, where the originating process is defective in any material respect, arising from non-compliance with a condition precedent to the bottom is bound to crumble. The defect in the originating process renders the entire proceeding a nullity and robs the court of jurisdiction to determine the case on the merits, as no court of law can assume jurisdiction on the basis of a defective originating process. See Okwe and Farm Milk PLC and another, Vatokwe and Sadiku and another. Citation for this authority supply. In Governing Council of National Teachers Institute, Kaduna and another, and Non-Academic Staff Union of Educational and Associated Institutions, NASU, 2018, Law Pavilion Electronic Law Reports, 44557, Court of Appeal at page 22. Yahaya JC observed thus, and I quote, the validity of originating process in a proceeding before a court of law is crucial and fundamental. It is an indispensable requirement or condition for the competence of the suit, effectually, the competence of the court to entertain it. Thus, where the originating process is invalid or even defective, it cannot activate the jurisdiction of the court. This is because a valid originating process is a condition precedent for the court to have competence and jurisdiction, end of quote. This preliminary objection was brought on two grounds. The first ground is that leave of this court was not obtained to issue and serve the originating process on the applicant, which is a company incorporated in Lebanon, outside the jurisdiction of the court. Secondly, the service of the originating process intended for the applicant on the first defendant is a nullity. In the written address in support of the application, learned counsel for the applicant abandoned the second ground. The objection is therefore anchored on the sole ground that leave to issue and serve the originating process on the applicant was not obtained in breach of Order 7, Rule 16 of the rules and Section 98 of the Sheriff and Civil Process Act. Order 7, Rule 16 provides, and I quote, all originating processes or other processes filed by any party before the court, which are to be served on any other party outside the Federal Republic of Nigeria, shall be with the leave of the court. Section 98 of the Sheriff and Civil Process Act stipulates that a writ of summons for service out of the state or the Federal Capital Territory in which it was issued may be issued as a concurrent writ with one for service within such state or the Federal Capital Territory, and shall in that case be marked as concurrent, end of quote. While Order 7, Rule 16 of the rules deals with leave to serve an originating process on a party resident outside the Federal Republic of Nigeria, Section 98 of the Sheriff and Civil Process Act deals with endorsement on the originating process where it is intended to serve it on parties who are resident within and outside the jurisdiction of the court. Neither of the provisions, in my respectful view, deals with leave to issue an originating process intended for service of the defendant who is resident outside the Federal Republic of Nigeria. I have come to this conclusion by giving the words used in Order 7, Rule 16 its ordinary meaning. And this flows from the provision of Order 7, Rule 15, Sub-Rule 2 of the rules, which provides that all originating processes or other court processes filed by any party before the court shall be served on any other party in any part of the Federation without leave of court. Order 7, Rule 16 then provides that all originating processes or other processes filed by any party before the court, which are to be served on any other party outside the Federal Republic of Nigeria, shall be with the leave of the court. The operative words are to be served. A further support is found in the heading of Order 7, Service of Processes. And a side note to Rule 16, Service of Processes out of Nigeria with leave of court. While by Section 3, Subsection 2 of the Interpretation Act, a heading or marginal note to an enactment does not form part of the enactment. Nonetheless, it serves as a guide to understanding the intention of the lawmaker. See Paul Iyabugbe and Commissioner of Police, 1992, Law Pavilion Electronic Law Reports 3505, Supreme Court, at page 17 to page 18. Osun State Independent Electoral Commission and another, and Action Congress and others, and Onyekwe and Udemma, citation supplied. Moreover, the word issue does not appear in Rule 16, and a cardinal rule of interpretation of statutes is that the court is to give words used in a statute their ordinary and literal meaning. It is not the duty of the court to go outside the words used and import an interpretation which is convenient to it or the parties or either of them. See Gafaro and Government of Kwara State and others, 2007, 1-2 Supreme Court, page 189, particularly at page 224. Section 98 of the Sheriff and Civil Process Act deals with endorsement of the word concurrent on an originating process for service on parties within and outside the jurisdiction on leave, not on leave to issue. Interpreting Section 98 of the Sheriff and Civil Process Act, the Court of Appeal in Governing Council of National Teachers Institute, Kaduna, and another, an Academic Staff Union of Education and Associated Institutions, NASU, held that the provision applies to this court where the process is to be served outside its territorial jurisdiction. In Social Democratic Party, Ambien and others, 2019, Law Pavilion Electronic Law Reports, 46871, Court of Appeal, pages 17 to 19 and 24 to 25. The Court of Appeal also held that failure to mark the originating process for service out of the jurisdiction of the court, where it was issued with the process for service within the jurisdiction concurrent, renders it voidable, and the defendant who complains of such non-compliance is entitled ex debitio justitiae to have it set aside, provided he has not taken fresh steps in the matter, which will amount to a waiver of the irregularity complained of. Thus, Order 7, Rule 16 of the Rules and Section 98 of the Sheriffs and Civil Process Act do not support the submission of learned counsel for the applicant that leave ought to be obtained before the issuance of the originating process involving a defendant who resides outside the jurisdiction of the court, and its decisions in Agip Nigeria Limited and Agip Petroleum and Caribbean Trading Facility Corporation and NNPC, cited by the applicant, were not based on Order 7, Rule 16 of the Rules and Section 98 of the Sheriffs and Civil Process Act. In any event, the address for service is Block 3, Plot 2, Abiodun Yusufu Way, Oniru Estate, Victoria Island, Lagos, within the jurisdiction of the court. So even though the applicant is resident outside the Federal Republic of Nigeria, the address for service is within jurisdiction, thus obviating the necessity to apply for leave to serve out of jurisdiction. See the case of Fayemi and Oni and others, 2019, 4-5 Supreme Court, Part 1, page 1 at page 21. Contrary to the submission of learned counsel for the respondent on his issue 2, there is nothing in this case which prevents the plenary objection, which prevents the plenary point taken by the applicant to cease to be won. By the pleading of the respondent, it is clear that the applicant is resident in Lebanon, and the address for service is the address of the first defendant. I observed earlier in this ruling that facts admitted require no further proof. The respondent admits that the applicant carries on business in Lebanon, from where it coordinates the affairs of the first defendant. Therefore, the question of evidence no longer arises. The rule on the distinct legal personality of a registered company from its subscribers is tried. See Section 42 of the Companies and Allied Matters Act 2020, and Onukusi and others, and the registered trustees of the Christ Methodist Zion Church, 2011, Law Pavilion Electronic Law Reports, 2702 Supreme Court, pages 18 and 19. Therefore, the fact that the applicant is a subsidiary of the first defendant is a subsidiary of the applicant does not make both one and the same person or collapse their corporate personality. For this reason, the provisions of Order 7, Rule 1, Sub-Rule H, Paragraph I of the Rules and Section 104 of the Companies and Allied Matters Act 2020 on service on a limited liability company are inapplicable to the applicant. It is the law that an originating process must be served personally and not through another defendant. See Order 7, Rule 1, Sub-Rule H and I of the Rules, Management Enterprises Limited, and Otu Soya, 1987, 4 Supreme Court, page 251, and PL Lizard Shipping Company Limited, and MV Western Star and others, 2019, 3-4 Supreme Court, page 161 at pages 182 to 183. To serve the process intended for the applicant on the first defendant, the respondent requires leave of the court pursuant to Order 7, Rule 1, Sub-Rule 3 of the Rules. This was not done, thus vitiating the service of the originating process on the applicant. The next point is the issue of waiver raised by the respondent. Relying on the case of Ezemo and Oyakire, the respondent submits that where a defendant enters appearance on the strength of an irregular service of an originating process, he is deemed to waive the irregularity by the defendant. He is deemed to waive the irregularity. The Court of Appeal in Social Democratic Party and BN and others, Supra, held that breach of Section 98 of the Sheriffs and Civil Process Act renders the originating process voidable at the instance I beg your pardon, please. Renders the originating process voidable at the instance of the defendant who complains of non-compliance and is entitled to have it set aside, provided he has not taken fresh steps in the matter, which will amount to a waiver of the irregularity complained of. I have carefully read the processes filed by the defendant. The first defendant entered the appearance, filed a motion for extension of time to file his defense processes and his statement of defense and accompanying processes. But the applicant entered conditional appearance and filed a preliminary objection. It cannot therefore be said to have taken steps in the matter and waive this right to complain of the irregularity. CCGG Nigeria Limited and Moses Aminu, 2015, Law Pavilion Electronic Law Reports, 24463 Supreme Court at page 19, and Marco and Omo, 2010, Law Pavilion Electronic Law Reports, 4463. Hello? Hello?
My lord, we can hear you, sir, but the recording has stopped from your end.
Okay. Okay, the time has elapsed. So in the circumstance, the first ground of the preliminary objection fails and it is dismissed. The service of the originating process intended for the applicant on the first defendant without leave of court is a nullity and hereby set aside. I make no orders to cause. Ruling is entered accordingly.
As the court pleases, my lord, we are most grateful for an erudite, well-considered ruling.
As a court pleases, we are most grateful, sir.
So, what is the next stage now in this proceeding?
My lord does not. My lord, can we apply for cost, my lord? We took steps.
I have already ruled. I said I make no orders to court.
Orders to court, yes.
As the court pleases. As the court pleases.
Yes. So what do we do now? We take a date. What is the matter for?
A date for trial, sir.
Respectfully, my lord, I don't want to be unfair to my learned colleague. He has to amend these processes. Your lordship has just struck out the second defendant. He has to amend this process. He knows he has to do that. He has to amend these processes. And he has to serve us and we have to respond. But my lord, we would agree to a date for trial. We are ready for the trial. We are more than ready for it. If he wants to go with these processes as they are now, we don't mind, but it's his own cup of tea. So my lord, we don't mind. We'll take a date for trial. We have only one witness and he has only one also. So my lord,
yes. My lord, we can ensure that our processes are amended. Okay, we need to bring an application. In that circumstances, I think the proper thing, subject to my lordship's directive, is for date for mention so that we can amend the processes accordingly.
My lord, if I may venture a little opinion, my lord. My lord, this matter, my lord remembers had a checkered history, and my lord has been extremely eager. I think if my learned friend puts in his papers before the next adjourned date and serves us, my lord would approve them. It's just to remove and just retain the only defendant. We can go for trial. It won't affect all of us, my lord. It won't affect us. I think we can take a date for trial, my lord, particularly because the interesting about this case was that both our witnesses and ourselves, we actually had to return from where we were because of this trial before Corona just struck us down, my lord. I will beg, the Lord has been extremely fair, even to us. We've had adjournments on both sides. If my learned friend, I respectfully suggest, puts in, it's just to amend. He's not changing, it's just removing one person. It's already done. It's just for him to do.
So how early can the amendment, because I don't know if there will be vacation this year, but we need to make use of every available opportunity now, seeing that we have lost so much time. So how early can parties come for trial?
My lord, we can file our papers, our motion for amendment before the end of next week, my lord, before Friday.
So you can file on Monday. Today is Thursday. You can file on Monday.
On Monday, very well, sir. Very well, sir. So we can file on Monday. If my learned friend on the other side has no objection to it, we can adopt it that day.
You come on Monday, 5th of July for trial. Monday, 5th of July for trial, if it's convenient for both parties.
It's convenient, sir.
My lord, may I do Oliver Twist, my lord? I have family obligations outside Nigeria, my lord. My lord, any date that my lord gives us between the 5th, between Tuesday next week and 25th, I will make myself available.
No, you can't get a date in June. The earliest you can get is July. And I'm giving you the first week in July.
Okay, my lord, it's convenient for me. Since convenient, okay, my lord.
It's convenient, sir.
Monday, the 5th of July, convenient to both parties?
As a couple,
okay. Just give me a few minutes. Let me incident this. This case is adjourned to Monday, 5th of July, 2021 for trial of the claim and defense. Please come with all your witnesses. I agree on documents ahead of time so we can move very speedily. Thank you. Once again, I apologize for staying you on. I appreciate your cooperation.
As a couple, that we should say thanks, my lord. That we owe the court the thanks. We thank the Lord for being so eager to work. I mean, Lord, please go on your vacation. Some of us need to go and sort out family issues during vacation.
I will. I appreciate you. Have a wonderful day.
You too, my lord. You're very grateful, sir.
Okay. What's the next case? Fatai.